Hi, my name is Rebecca Jacobs, and I am the professor for the Employment Law 2 class, which you will be taking in July of 2019. And the reason I'm making this recording video is that there are some things we will be talking about during our first day of class relating to absenteeism, leaves of absence, and a lot of the discussion will rely heavily on what the students have learned in Employment Law 1 relating to the Americans with Disabilities Act and the Family and Medical Leave Act. So to make sure that everyone taking the class can get the most out of this discussion and the group exercise we will be doing, this is essentially a short primer on disability law and FMLA. I'm not going to dive deep into all of the details surrounding the ADA and the FMLA, but I'm going to give you enough information for you to come into class and be able to understand our discussion and get something out of it. And if you have any questions upon listening to this, please call me, text me, email me. My information is available on Canvas if you need it. My number is 614-937-8168. And with that, I am going to get started. So we're talking about absenteeism, people being gone from work. Ordinarily, under most company policies, people can be fired if they are absent too much from work. It kind of goes without saying, if you don't show up for work and you don't have a good reason for it, then you are not going to have a job for very much longer. Now, most companies have their own absenteeism or sick leave policies. Sometimes we'll see it in the form of personal time off or paid time off, where you get a certain chunk of days per year to use for any reason, whether it's a child's parent-teacher conference or your own flu or things like that. Some companies will have a specific number of sick days that someone can take and a specific number of personal absence days that a person can have. And then they'll have some additional things like bereavement leave and things like that. And there are some states, as we'll be talking about in class, when you come into class, there are some states that are even providing additional protections for their employees in the form of paid leave for their own illness or the illness of a family member, or even if school has been canceled due to weather. We see that in some of the northern states that deal with a lot of snow and ice. So every company will have its own policy on how it's going to manage absenteeism. And if there were no federal laws applying to the employees who are at this company, then if they are sick too many days, if they exceed the PTO policy or the sick leave policy, then they can lose their job. And that would be considered a legitimate termination. We are in an employment at will situation most of the time anyway. So it would not be a problem to say this person has been sick too much, they've exceeded our absence policy, now we can fire them. However, we do have federal laws that essentially overlay and work with and sometimes trump these sick leave policies. And we're going to talk about two of them. And these are the two biggies, and we're going to go into some details about them. The first one is the Americans with Disabilities Act, and the second one is the Family and Medical Leave Act. And I'm going to discuss the ADA first. The Americans with Disabilities Act applies to all employers across the country who have 15 or more employees. Now, this number is the number under the federal law. However, a lot of states have their own kind of mini versions of the Americans with Disabilities Act where they apply it to smaller employers. For example, Ohio has a similar disability law, and it applies to employers with 4 or more workers. So wherever you are working, wherever your company has operations, you want to make sure that you're aware of whether a state corollary to the Americans with Disabilities Act may apply to a smaller workforce. So what exactly does the Americans with Disabilities Act do? Essentially, it says that if a person has a certain kind of physical or mental impairment, but they can do the essential functions of their job, then the company has to make reasonable accommodations to help them do those essential functions. There are a ton of terms of art in the sentence I just said. But we're going to focus first on reasonable accommodations. It can be a physical change to the workplace. Perhaps you need to bring in or install a ramp for a wheelchair to be able to get from one place to another. Perhaps you have someone who is disabled or who has a disability in the ability to hear, and they may need an interpreter to come in for certain meetings or certain events. The reasonable accommodation can also be a change in policies. It can be a change in your absenteeism policy, essentially excusing the person from having a number of absences if they need to take time off to handle medical concerns that relate to the condition that has resulted in them having a disability. It can be so many, many different things. There's no list from the Equal Employment Opportunity Commission that says, hey, here are the reasonable accommodations you may have to do. It's really flexible. The law intends that the employer and the employee work together to try and figure out what do we need to do to make it so that this person can perform the essential functions of their job. So that is the basic rule about reasonable accommodations, and we have to unpack a lot of what we just discussed, but I wanted to set the groundwork for what is a reasonable accommodation. The reasonable accommodation we're going to be talking a lot about in class is leave of absence, whether it's a long leave of absence or whether it's a short period of missing a few days, and perhaps a person now has exceeded the sick leave entitlement with their company. But this is a very common leave of absence, very common accommodation that we see is when someone has to take a leave of absence. So how does a person become entitled to have a reasonable accommodation offered for them at work? What is the threshold they must cross to have the law give them this protection? So now we're going to talk about how a person establishes that they have a disability under the Americans with Disabilities Act. The first piece is that the person has a physical or mental impairment, such as diabetes, or they have an inability to walk, or they have cancer. Infertility comes under this. I'm not going to get into a very deep discussion about all of the different physical and mental impairments, but essentially it is some kind of condition that a person has that is either permanent or it can be something that's temporary, but we're going to look for something that's pretty substantial and significant in its impact on a person's activities. If it is something that's temporary, like a broken leg or something like that, some things that are temporary and don't have a very severe or significant impact on a person's activities, those may actually not rise to the level of a disability under the Americans with Disabilities Act. Now, so the first question is, does the person have a physical or mental impairment? And then the second piece is that this impairment must substantially limit a major life activity. It has to affect how the person does a major life activity. And major life activities can include breathing, seeing, hearing, walking, concentrating, lifting, sleeping. It's a very, very long list, and you'll see it in the materials. If you're following with the materials, you'll see kind of a list of what the major life activities are. So if a person has an impairment that substantially limits their ability to engage in one of these major life activities, then the person has met the definition of being an employee with a disability. So that's kind of the first piece of the analysis, and then we have to go a little bit further. Not only do we look at what the position exists to do, but we ask what functions are necessary to enable this position to be successful. For example, with the ticket agent. That person obviously has to be at the airport working with their computer and their printer and dealing with the customers. This is something that they have to be present to accomplish. Think about all of the other jobs where a person actually needs to be there to do their job. A dental hygienist, a nurse, an anesthesiologist at the hospital. Compare and contrast this to positions where someone may be able to complete a task remotely. For example, someone who is doing medical transcription. They can probably do this from home or from any other location. Or if someone works on marketing brochures, they could probably do this from any location. So think about where the person needs to be to do the position, and if the person needs to be present at the workplace, then you need to say that presence at work is an essential function and that regular attendance is an essential function. So this is how we decide what the essential functions are for a position. Now, the reason why it's important to know what the essential functions are is that you may have a situation where a person is requesting an accommodation where they don't have to perform a certain task for their job. They say, hey, my condition makes it difficult for me to accomplish this task. Therefore, I ask as a reasonable accommodation that you remove this task from my job responsibilities. Now, if the task is an essential function, then it is not a reasonable accommodation to remove that task from that person's job function. And so that is why it's important. The employer really gets the chance to say, these are the essential functions of the job, and the best place for them to say that is in the job description. In fact, job descriptions are so important for this function that the very last class of this session, you guys are going to prepare a job description. I'm going to give you information about a particular job, and you guys are going to write the job description to get some practice and to get some understanding about the importance and the need to make sure that essential functions are identified as essential functions in the job description. So what are some other examples of reasonable accommodations? Well, there was a reasonable accommodation request for someone who had difficulty focusing on tasks due to ADHD, and one of their functions was to provide data up the chain of command about their restaurant. They were a regional manager, and they needed to give information about how many labor hours were used over the past week, how many food products were ordered and used over the past week, so that the people up higher in the chain of command who were dealing with logistics could say, okay, well, for the following week, we're going to send more boxes of, let's say, hamburger patties because you had a higher demand, or we're going to make sure that you have more people scheduled to work. So there was a timeliness element to getting this information. The person was having difficulty getting the information on time to the higher in command, and they said, well, look, I've got a condition, it makes it difficult for me to focus, and I'm asking as a reasonable accommodation that I get an additional week to provide all this information. Well, this wasn't going to work because this was going to essentially eliminate the essential function, one of the essential functions of this job, which was timely communication of information so that logistical changes could be made as needed on a timely basis. So what are some of the other restrictions on accommodations? So we've already discussed one, which is it cannot eliminate an essential function of the job. Another restriction is that it has to be reasonable. It cannot be too burdensome on other employees, and it actually has to be feasible. It has to be something that can be done. And another question is, even if something is considered a reasonable accommodation, the next question is, does it impose an undue burden on the company? Now, some companies will say, hey, it's going to be too expensive for us to have to install this thing or make this change to our computer system or to our monitors. And the EEOC in general has been quite unfriendly to arguments of financial cost. They say, hey, look, have you exhausted your research on any grants that are available to help you make this cost? They look at the size of the company. A company the size of Walmart is going to be able to afford a lot more by way of accommodations than a small 20-person company that may not have the same amount of revenue and capital to spend on these things. So it's all, you can see it's all, there's no black and white rule here. It's all kind of an analysis. We have an analysis as to what are the essential functions. Hopefully they've been outlined in the job description. We have an analysis as to the thing that's been proposed, the change in the workplace. Is it reasonable? Can it be done? Does it impose burdens on the other employees? Does it enable the person to actually perform the essential functions of the job? Does it pose an undue hardship or undue burden on the company? So that is the analysis we go through to determine whether a reasonable accommodation shall be offered. Now, what happens if you have an employee and an employer who are at odds about the appropriate accommodation? So here's an example. We have a cashier at a retail store, and the cashier has been having significant problems with her knees, and it is very painful for her to stand. She has requested a leave of absence of 2 weeks in order to have some rest, ice her knees, do a little bit of therapy, and she believes, and her doctor has said, yes, I believe so too, that when she returns from this 2-week leave of absence, she will be able to perform her job and stand and do what she needs to do. Now, let's say the employer says, well, that's great. We kind of need you here. We're in a really busy time here. What if we just have a stool? What if we have a stool that you can sit on so you don't have pressure on your knees? And assuming that the doctor for the employee says, well, yes, that is also a way to enable her to perform her job because she'd be sitting, she wouldn't have pressure on her knees. Then we have a situation where we have 2 alternative accommodations, each of which would be effective. How do we choose between the 2? What does a court or the EEOC require an employer to do in this situation? And the rule that courts have repeatedly endorsed is that the employer can choose whichever one. As long as it's effective, the employer can choose it. It is not illegal for the employer to tell the employee, we're going to do something other than the accommodation you would prefer. So as long as it's effective, as long as it allows the person to perform their job, then the employer can choose that accommodation and move forward with it. So the next question is, I mentioned doctors. The next question is, how do we kind of sort through the information to find out whether an accommodation would work? How do we find out if the person has a disability? How do we sort all of this out? If a person comes forward and says, I have a disability and I need this accommodation, does the employer take their word for it, or can they dig and get a little bit of information from the employee? And the answer is it depends. It depends on whether the condition is obvious or not. If someone is in a wheelchair, then the employer would be out of line saying, well, we don't know if you have a disability. Can you get us some documentation from your doctor? But if the disability is not obvious, the employer can say, okay, great, I hear you. You're making a request for a change in the workplace. We do need to get some information, so please get something from your doctor in writing that explains, what your limitation is and what the accommodation you're requesting is and how that accommodation will allow you to perform the essential functions of the job. Now, we cannot, in this document, the employer cannot say, hey, just tell us what your disability is, tell us what your medical condition is, and we'll sort it out. Instead, the law really wants us just to kind of get at the nuggets of the analysis. What is there a physical or mental impairment? Is there a substantial limitation of major life activities? Is there an accommodation that would allow this person to do the job, and how would it do so? And this would be the opportunity, if the person needs a leave of absence, this would be the opportunity for the doctor to say, hey, this person needs let's take, for example, an employee who's been diagnosed with clinical depression. They could say, hey, this person needs to take a month off to deal with their medication, make sure their medication is at the right level. They need some time to adjust to this, and we expect the person will be able to come back to work when they are done with this. So here, the doctor has indicated that the accommodation has indicated what the accommodation is, and that it would allow the person to come back to work. So the documentation is supposed to recap, is supposed to substantiate the impairment, the substantial limitation on major life activity, and the need for the accommodation. A couple of quick important points about getting the documentation from the physician. This is something that really needs to go through human resources. The last thing we want is for a supervisor or a manager to be communicating directly with the employee's physician. So the way that this should play out, assuming that we're at a company that has an HR department, the way it should play out is the employee will ask the supervisor for a change in their work situation, whether it's a leave of absence or they need to get a different monitor for their computer or whatever the case may be. And the supervisor then needs to get this to HR. It's important that HR is the one dealing with this situation. We don't want the supervisors to be having in-depth discussions with employees about their medical conditions. So ideally, this would then come to human resources. Human resources would talk to the employee and say, hey, we understand you have this request. We just need your doctor to fill out this information. Here's a letter explaining what we need. Please get it to your physician, and please get that information to us as soon as we can. So then the employee goes, they get the information from their doctor, they provide it back to human resources. And then we go through the interactive process where the company considers, okay, well, here's the accommodation that's being requested. Is it feasible? Is it reasonable? How much of a burden is this going to pose on other employees? And then if it's problematic, then they have to go back to the employee and say, well, hey, why don't we try this instead? This should accomplish the goal. For example, like the stool, this should accomplish the goal. And so we have this interactive process where the employee and the employer, through the HR department, are going back and forth and figuring out what is the right way to do this. The failure to engage in the interactive process is a problem for either side. If the employer doesn't follow up on the request for an accommodation and engage in the interactive process, then the employer is going to be in trouble, and it's going to be a huge problem for them in a resulting lawsuit under the Americans with Disabilities Act. If, on the other hand, the employee is the one who stops engaging in the interactive process, for example, let's say the employee never gets the information from the doctor, never responds to any information requests, then the employee is the one who has dropped the ball on the interactive process. And if they later say, hey, I didn't get the accommodation I needed, they will more likely than not lose their lawsuit because they didn't get the information to the employer that they were legally obligated to get to the employer. So this is information, this is an analysis that we talk quite a bit about in the class, and I believe that this is sufficient for us to have at this time and going forward. But I'm going to talk about a few additional examples just to kind of flesh this out and make it a little bit more understandable of how leaves of absence and reasonable accommodations and the whole definition analysis come into play. So we're going to do some examples here. So example number one, a person who suffers from epilepsy gets put onto new medication. Their doctor recommends that the person takes 3 weeks off of work to adjust to the new medication. And when the 3 weeks are done, the person is expected to be able to return to work. Those 3 weeks would be, assuming it's feasible and reasonable, in most cases it will be. It would be very unusual to have a court say that would be, or for an employer to say that would be too difficult. It depends on the circumstances, but more likely than not, this would be considered a very reasonable accommodation, especially since the person will be able to come back to work when the 3 weeks are done. So even if the person has exhausted all of their sick leave or PTO leave, they still get to take those 3 weeks off and come back. Another example is we have an employee who has diabetes and is dealing with macular degeneration. This is where the eyesight is degenerating and it's a complication of diabetes. Sometimes people can get relief and even reverse the damage if they get injections of certain medicine into their eyeballs. So a person who is dealing with this needs to take 1 day off each month to get an injection in their eyeballs to manage the degeneration. And sometimes they need to take the following day off as well because of the discomfort in their eyes. This would be considered a reasonable accommodation absent very unusual circumstances. So even if the person didn't have enough sick leave to cover them to take 1 or 2 days off a month for this, they have a disability, and being able to take that time off helps them to be able to come back to work and do what they need to do at work. Third example, a person with severe arthritis has hip replacement surgery and is out of work for 2 months. When the 2 months are done, the person will be able to return to work. So again, the person has a disability and the arthritis that has a substantial limitation on their ability to walk, and they need to get the surgery in order to get better. And so the 2 months would be considered a reasonable accommodation. Now, bear in mind, if we start to look at leaves of absence that are much longer, like 6 months, a year and a half, then we're running up against the reasonableness factor and sometimes even going into the undue burden analysis. And that is because a lot of employers, especially the ones who, depending on the function and the size of the employer, they're going to say, look, it's not reasonable, it's not easy for us to have someone that we need out for this long. What are we supposed to do? Are we supposed to hire a temporary employee but tell them you're going to be fired when this person comes back from their medical leave? Some companies have kind of a no-fault absenteeism policy where they say if you are gone for more than a year, regardless of the circumstances, your employment is terminated and no questions asked. And the EEOC is quite hostile to those types of agreements, but a lot of courts are saying, look, if a person's not able to come to work for a year, obviously they're not accomplishing the essential functions of their job because they're just not doing it. They're not there. And so the question really boils down to, is there a good likelihood that this person is going to be able to come back to work soon? Or are we kind of heading down the path of an indefinite leave, whereas we get as every time HR checks in, it's like, well, I haven't been cleared yet, but check with me in a couple weeks. If we're looking at a leave of absence of 6, 9, 12 months where the doctor has given pretty good information that this person will be able to come back upon the completion of that leave, then it's more likely than not going to be seen as a reasonable accommodation. But if it's more of an indefinite leave where we're just not sure, then more likely than not, the court is going to say, no, that's not reasonable for many reasons. First of all, the person's not performing the essential functions of their job, and it's not fair to impose that burden on the company, and it can even qualify as an undue burden under most courts' analyses. There is one other very important thing for us to talk about with respect to the Americans with Disabilities Act, and that is the fact that a person can get an accommodation for their condition, for their disability, at any time during their employment. They can get an accommodation in connection with the application process, in connection with the job interview. If someone needs some kind of a physical accommodation to enable them to attend the job interview, you are required to provide that. There is no waiting period for someone to undergo before they are able to take a leave of absence under the Americans with Disabilities Act. If you have someone who needs a leave of absence, it doesn't matter if they've worked there for 1 day or for a year. Now remember this, because we're going to contrast this with the next law, which we are going to discuss. And that law is the Family and Medical Leave Act. This is also a federal law that applies to larger employers. and there is a waiting period, which we will discuss in just a minute. So we are now going to turn our attention from the ADA to the FMLA. Under the FMLA, an eligible employee can take time off for their own serious health condition or the serious health condition of a parent, child, or spouse. This person can take up to 12 weeks within a 1-year period, assuming that the doctor has provided sufficient certification of a qualifying serious health condition. Now, in addition to taking time off for a serious health condition, an employee can also take time off upon the birth of a child, upon the adoption or bringing into the home for foster care of a child, and for any type of prenatal care. I mentioned a moment ago that this applies to larger employers. An employer must have 50 or more employees in order to be covered by the FMLA. And it's not just 50 or more in general. It's 50 or more at either one particular work site or at more than one work site, so long as those work sites are within 75 miles of each other. So this applies to not only larger companies, but let's say that you have a fast food franchise business which has 3 restaurants within a 75-mile radius, and in each store, each restaurant has only 40 employees. Because they are within the 75 miles, we would add all of those employees up to say, yes, each of these employees is working for a covered employer who must comply with the Family and Medical Leave Act. As I mentioned before, there is a waiting period. An employee must have worked 12 months or more for this employer, and they must have worked 1,250 hours within the past 12 months. Now, there's a little twist here that you need to be aware of. And we talked a lot about this in the Employment Law 1 class, so I'm not going to talk about it too much now. But the 12 months, so it's a 2-piece eligibility requirement. And the first piece is the 12 months, having worked 12 months. That does not need to be consecutive. You could have someone in 2017 having worked 6 months, and then 2018 they worked 6 months. And you would add all of that together to say, yes, we have the 12-month eligibility requirement satisfied. So that's the first piece. The second piece is that the person must have worked 1,250 hours within the last 12 months. Now, unlike the 12 months we were just talking about, when we talk about the 1,250 hours, those do have to be within the last year. So there is no adding together bunches of hours to get to the 1,250 requirement. Today is April 4th, 2019. We're looking back to April 4th, 2018. Has that person worked 1,250 hours over the course of that year? And how do we calculate the 1,250 hours? Those are hours for which the person must be paid. So if the person is working 5 hours a day and takes a half-hour meal break, even though the meal break is going to be in the middle of their day, they don't get to count that towards their FMLA entitlement. They only count the hours for which they are entitled to be paid. But I'm not going to spend too much time talking about that now, since that's a little bit beyond the level of detail that we need for your purposes. Now let's talk about the reasons for leave that would entitle a person to take FMLA leave. So this, of course, assumes that the company is large enough to be covered by FMLA. It assumes that the person has met their eligibility requirement of having worked the 12 months and the 1,250 hours. So now we're going to talk about, essentially, there are 3 different reasons for which a person can take leave. 1, there's now a child in the home. 2, the employee's own serious health condition. Or 3, the serious health condition of the employee's spouse, parent, or child. So let's first look at the child who comes into the house. Now, why don't I say that a child is born to the employee? Because this applies not only to a child who is brought in through childbirth, but also a child who is brought in through foster care and who has been adopted. For this purpose, as well as for any other eligible purpose under FMLA, the employee can take 12 weeks of leave off. So if the person has a child and they're eligible, they get 12 weeks. Now the question comes up, and this is as good enough a place to talk about this as anywhere else. The question comes up, well, how do we measure the 12 weeks? There are a few different ways to measure the 12 weeks. I'm going to touch on them just very, very briefly. If you have questions about it, text me or email me and we can go into it in more detail. But some companies use the calendar method. So as of every January 1st, the person now has 12 weeks available to them, no matter how much they used in the previous year or how much they used in the past few months. As soon as we get to January 1st, boom, they have their 12-week entitlement. Or you could have an anniversary date. Let's say they started employment on May 1st. Every May 1st, they have that 12 weeks automatically. A lot of employers use the rolling back method, which is where when the person comes in to make a request to take FMLA leave, it is at that point that the employer just looks to see how much time they have available. So what they do is on the day the person comes to ask, let's say it's May 1st, the employer says, okay, well, how many weeks of FMLA leave have you used in the past year? Let's say the person used 4 weeks within the past year. So we take 4 away from 12, we have 8. So now the person has 8 weeks of leave available. So let's run through a quick example with the childbirth situation. So let's say that we have an employee named Mary who was pregnant. Now, being pregnant and needing prenatal care, as we'll talk about in a moment, spoiler alert, that actually is a serious health condition. So let's say that Mary is entitled to 12 weeks, and let's say that she actually has to take 4 weeks off because of bed rest, because of complications arising from her pregnancy, and she needs the bed rest, but once she gets the bed rest, she's going to be fine. So she takes 4 weeks of FMLA leave. She comes back to work, works a few more weeks, now her baby is born. How much time does she have? Because she used 4 already, even though it was for something other than the birth of her child, it still was FMLA qualifying, and so it still pulls from that FMLA bank. So now she has 8 weeks available. And this is a common misperception that you may run into if you're dealing with FMLA in the workplace, is you may have people believe that, well, we get 12 weeks of FMLA leave, but if the 12 weeks are for different purposes, or if the leave is for different purposes, then it refreshes every time something new comes up, and that is not correct. You get 12 weeks for whatever purpose. So even if someone is taking time off to care for a parent and not for themselves, if they've used up their 12 weeks for that and now they have their own serious health condition and they don't have the 12 weeks available, the mere fact that it is for a new reason does not entitle them to any additional time. So going back to the childbirth scenario, so Mary has 8 weeks available to her of FMLA leave. And she doesn't have to take it as soon as she has the child. She can actually take those 8 weeks of what we call bonding time at any time until the child is 1 year old. So she could do it right away, as most people tend to do. So she gives birth, she takes 8 weeks off, and then she comes back to work. Or let's say that she and her husband have, or the father of the child have made arrangements, so he's home with the child for a few weeks, she comes back to work, and then they swap off. So she's not required to use the 8 weeks immediately upon childbirth. She just has to do it within the first year. So that is the childbirth, the fostering, the adoption. Interesting point. If a person needs to travel in connection with an adoption, that is also going to be covered by FMLA. That will be an FMLA qualifying reason, and it will pull down or deplete, for lack of a better word, the FMLA time available in their FMLA bank. So that is the childbirth reason for FMLA leave. Let's move on and talk about a serious health condition. Now I want to kind of open our books again back to ADA just for a moment. We're going to have a little ADA FMLA comparison here. Do you remember how we talked about whether someone met the definition of being actually disabled? We looked at what they could do. We looked at what their impairment was and how their impairment actually affected their major life activities. It was very functional in terms of the person's abilities and what they can and can't do. FMLA in terms of determining whether someone has a serious health condition, whether it's the employee or one of the employee's family members, it's very mechanical. It doesn't look so much at what the person's functions are. It looks more at can the person come to work or engage in other daily living activities? And essentially, has the doctor said this is a serious health condition? If a doctor certifies the person as having a serious health condition, as having met the requirements for a serious health condition, it is very mechanical and the person is entitled to the leave. So there are some easy ways to see whether something's a serious health condition, because the regulations have quite a complex series of definitions as to what constitutes a serious health condition. One of them is prenatal care, as I previously mentioned. Another one that is pretty easy to achieve, or in terms of proving that it is a serious health condition, is hospital admission. If someone is admitted to a hospital, then they have a serious health condition. It doesn't matter what they were admitted for. See, this is that distinction between disability and FMLA. It doesn't matter why they were admitted to the hospital. They could have an infected hangnail that doesn't really affect any of their daily activities. If they have gone in the emergency room and now they're admitted, they have an overnight stay at the hospital, that time, whatever time they lose in connection with this condition, is going to be covered by the FMLA. It's going to pull down from their FMLA leave bank. So hospital admission. Next, we have what's considered continuing treatment. Again, very mechanical and very important to understand. And this is something we are going to be covering in the group exercise in our class. So pay attention to this and ask me questions if you don't understand it. And we can also talk about it a little bit more before class as well, or during class if you have some additional questions about it. So for something to be For a condition to qualify as being a serious health condition under the continuing treatment definition, it really depends on how often have they seen their doctor for this condition, plus how long has this condition rendered them incapable of working. Okay, so we're looking at incapacity from work for more than 3 calendar days. They have to be unable to work for more than 3 days. 3 days, if they're just out for 3 days, that's not going to be continuing treatment serious health condition. It has to be more than 3 days, so 4 or more days that they're unable to work. And then, in addition to that, they either have to have 2 visits with a physician or healthcare practitioner within a 30-day period, or they have 1 visit to their healthcare practitioner and then they get put into some sort of a follow-up regime. So, for example, let's say they go to their doctor because they have a problem with their foot, and the doctor says, okay, well, I'm treating you for your foot. We've done some x-rays. I don't really see anything that I can do for you in terms of a splint or a cast or anything, but I'm going to have you go into physical therapy so that you can try and get this muscle working again better. This is now, if this condition with the foot has rendered the person unable to work for 4 or more days, this is going to be a serious health condition, because not only do we have the incapacity, we've got the 1 doctor visit and we have a follow-up regime. So anytime the doctor puts someone into some sort of a continuing treatment regime that the doctor's kind of overseeing, that is going to be a serious health condition. Now, prescription medicine actually is considered that follow-up regime. So if they have 1 doctor visit and they get prescribed medicine that they have to go to the pharmacy and collect with a prescription, that's going to satisfy the continuing treatment definition. Now, if the doctor just tells them to take an over-the-counter medicine, that is not considered continuing treatment. So if you have, let's say we have Mary and Bob, and they each have bronchitis of some sort, and Mary's doctor, she goes to see her doctor, and her doctor just tells her to drink lots of water, take ibuprofen, get lots of rest. Now, she does not have a serious health condition because there is no regimen of continuing treatment. Now, Bob goes to his doctor for bronchitis, and the doctor checks him out and says, I think we need to prescribe you these steroids and this and that and the other thing in order to help your lungs get better. Now, he does satisfy the definition of serious health condition because he had the one doctor's visit and now he's in a regimen of continuing treatment. So now you understand that. A couple other things that can be serious health conditions, and these usually come up when we're dealing with an employee who is seeking leave to care for a family member's, due to the family member's serious health condition. But we're talking about long-term conditions for which treatment may not be effective, chronic conditions like diabetes, epilepsy, things like that. That could be the employee's own condition as well. But essentially, it's longer things that may not cause incapacity, but that a person needs to have somewhat routine time off, either for doctor's visits or because they're having complications. And those things are going to be considered serious health conditions as well. We do see some of those. We see a lot of the continuing treatment one with the certifications. We do see a lot of the chronic ones as well when we get to migraines. And that can be a problem when the person is trying to take lots and lots and lots of little chunks of time for that serious health condition. But we'll talk about that in just a moment. I'm going to push that off for just a few minutes. We'll come back to migraines and intermittent leave in just a minute. So when we talk about the employee's family member, it's important to define who a family member is. Family member is going to be the employee's parent, the employee's spouse, or the employee's child. It does not include in-laws. It does not include grandparents. And actually, it does not include children who are 18 years old or older unless the child has a disability that renders them unable to take care of themselves. So generally when we're talking about child, we're looking at someone who is under 18 years old. As we will talk about in class, a lot of states are implementing their own family leave protections, and these states are expanding the definition of a family member to a pretty broad degree. And we'll talk about that in class. I'm not going to talk about that now. So how do we determine, I mentioned before about how mechanical this is, that we're looking for the doctors to give us the certification to tell us, yes, this is a serious health condition, no, this is not. It is not up to the HR or the leave professional to sit there and scratch their head and say, okay, well, this condition this person has, this migraine or this hangnail or this foot problem, is it not a serious health condition? What happens is the person will say, I need time off because of this medical issue. The company will respond by giving them their FMLA paperwork, including a notice saying, hey, this is how much time you are not eligible. This is how much time you have in your leave bank. Please get us a certification form. The employee then takes the certification form to their physician or to the physician of their family member, and then the employee has 15 days in which to get that certification form filled out by the healthcare practitioner, by the physician, and get it back to the employer. So HR doesn't have to analyze the medical condition. What they do is you just put the gears in motion, get the notification out, tell them about their eligibility, tell them how much time they have, get the certification back. Look at the certification. Does the doctor certify that there is a serious health condition? Do they not? What do we do, however, if the paperwork comes back from the doctor and it doesn't seem, or let's say you can't read it, or let's say that it's incomplete. You tell the employee, hey, you need to get this clarified, get this legible, you need to get this information filled in, and then they have a short period of time in which to take it back to their doctor, get it completely filled out, and then bring it back to the employer. If the employee fails to do that upon request, then someone who works for the employer can contact the doctor, but they're limited to getting that information in the sheet. Never, ever, ever should someone get on the phone with a doctor and say, hey, tell me about the condition. What's the diagnosis? You cannot go beyond whatever is in that form, because that would be a violation of not only the FMLA, but also the disability laws, which protect employees' medical information, that give them some degree of privacy. There are very specific circumstances under which you can request medical information and medical exams, and FMLA paperwork is not a green light to get information. You are limited to what is available on the form. So if there's a blank missing and the employee has failed to get that filled in, then yes, an HR professional, a doctor who works for the company, someone like that can call the doctor, the employee's doctor, and say, hey, we need to get this information filled in or clarified or made legible. The person who calls from the company can never, ever, 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 ever be the employee's supervisor. It's got to be someone outside of that chain of command. Well, anyhow, so now we know what we do if there's information missing. What do we do if we get it? There's all the information is on there, but it's like, oh, come on. How can this thing be a serious health condition? It doesn't seem possible. And if you talk to seasoned HR professionals, a lot of times you'll find out that maybe in the place where they work, the town they work in, the industry they work in, there may be a doctor or two out there who has a bit of a reputation for certifying lots and lots of things that really don't seem like they're serious. So what do? And FMLA actually gives employers an option to get a second opinion, and the employer gets to choose who the doctor is that employee visits to get that second opinion. And that second opinion doctor is essentially just going to examine the employee and fill out a blank certification form. And it cannot be a doctor that the employer regularly uses. So if a company has a doctor that they're always sending their workers' comp people to or stuff like that, you can't use that doctor. You got to find a different doctor in the community, send the employee to them, and if it comes back that if it says it's not a serious health condition, what do? Now we have a certification that says that there is a serious health condition. We have the second opinion that says that it's not. What do? Well, FMLA law says get a third opinion. Now, to pick this doctor, the employee and the employer actually have to agree. They have to choose a doctor that they both can agree on. And then whatever that doctor says, it is binding. Whatever that doctor says, that whether it's a serious health condition or not, it is binding, and that is it. So now we have our certification in place. Only upon the initial certification of a serious health condition, only at that initial point can we get the second opinion. You can't wait for 6 months and say, oh my gosh, this person's migraines are out of control, and I think they're taking way too much leave. I don't think it's necessary. What can we do? We cannot send them for a second opinion at that point. The window for a second opinion has closed. However, the law allows employers to get recertifications. Essentially, you're sending the employee back to their doctor at specific times and getting the paperwork filled out again. So it's still that same doctor. It's just a recertification. The law provides very specific time intervals in which to do it. But if circumstances have changed significantly, like the duration of the leave is now longer, the number of times they have to be out per week is now longer, or let's say you have come into possession of objective evidence that the person, that they cast doubt on the validity of the leave, then you can recertify. Like, let's say that the person is on leave for a significant knee problem, and they've been out on leave for many, many weeks, and you have to wait now at this point because you may not be allowed you may not be in one of those intervals where you can get recertification and you're waiting. But let's say that someone who works for your company sees this person out and about in the community doing very physical things that do not comport with whatever the knee condition is. If we have objective evidence of this, then the employer can ask the employee, hey, we've come into information that you were being very active and we want you to go back and get a recertification. Another reason for recertification, and this comes up with intermittent leaves, is if the person's pattern of absences don't seem consistent with their medical condition. So I've mentioned intermittent a couple of times, and I apologize, I haven't defined it yet, but intermittent leave is where a person is not taking a very large chunk of leave, like a week, 3 days, 2 weeks, whatever, but they're taking like a couple hours at a time. So sometimes you have this with prenatal leave. If someone has significant morning sickness, maybe they're taking a half hour of leave every morning so that they can take care of business with feeling nauseous and do what they need to do. Sometimes you have someone who has a medical condition where their intermittent leave is they need to go and get treatment once a week or once every other week. And so they're able to take these very small pieces of time in order to do what they need to do. So their absences are excused because they're covered by FMLA. Now, let's say that a person has migraines and their certification says that they may need to take a couple hours off once a week or so to deal with their migraine, but this person is consistently gone Monday mornings and Friday afternoons. Monday mornings, Friday afternoons. What do you do? Is this reason for recertification? Yes. What you want to do is you want to print up a copy of their absenteeisms, their attendance record, and send that with the certification form to the doctor and ask the doctor specifically, is this pattern of absenteeism consistent with the condition for which you have certified them as having a serious health condition? So that's an available, control mechanism is a good way to put it, to try and prevent people from taking advantage of the law that's available. We want them to use the FMLA leave to excuse their absences, to cover their absences where they actually have that medical need or their family member has a medical leave. And unfortunately, there are circumstances out there where people are using it to cover absences for other reasons, but then they get the protection of the law because of whatever certification they were able to get. So through the second opinion, through the recertification, these are mechanisms the employer can use to try to control that and make sure that the FMLA is being used for legitimate purposes. Now, there is no exception for undue burden. Remember, with ADA, if a person was going to take a long leave of absence, if it was going to put an undue burden on the company, let's say it's a medium to small size company that's still covered by the ADA, and this is the only person who can do this, and they're going to have to hire somebody else to cover this because it's just too important of a function, as long as the employer has documented that this is an undue burden and they're able to prove that in court, they could be excused from providing that leave to that person and essentially terminate them. Of course, that would be a pretty strong fight, and you could see a judge or a jury going either way on whether that actually is an undue burden or not. But there have been some very supportive judges in the federal court system who have supported employers and thus thrown out disability causes of action under relatively similar circumstances. So it's a toss-up. There are some provisions in the law where the employer could say, well, I just can't do this. It's not feasible for my business. And that's under the ADA. FMLA, we don't have anything like that under FMLA. You have a very important worker, very important set of skills, and they have to take 12 weeks and it's going to put your business in a world of hurt. They get that time off and they get their job back when they're done. There's no undue hardship exception here. Now, is the FMLA leave paid? It is not paid under federal law. And employers actually can require, but it needs to be written down in your employee handbook, it needs to be written down in your FMLA policy. Employers can require that employees run their paid time concurrently. So let's say you have someone who needs to take 12 weeks off to care for their mother with Alzheimer's, and they have 3 weeks of vacation available. if you've put it in your policy, you can tell that person, hey, you have to run your 3 weeks of vacation at the same time. So yes, they are going to get paid during those first 3 weeks, but then they're not going to have any vacation left when they're done with their FMLA leave. And you'll see that some of the states that have put together the Family Leave Acts on the state basis, some of them include paid leave. And we'll talk about that in the class. It's not a significant amount of pay, but it is something that is going to help those people who are taking the leave out. Now, when the person is done with the FMLA leave, they are entitled to come back to an equivalent position. It doesn't have to be exactly the same, but it needs to be pretty much the same. So they need to be making the same money. They need to have, relatively or substantially similar prestige and duties and responsibilities. But it doesn't have to be exactly the same. You should shoot for getting them to as close of a position as possible. If for some reason it has to be a different job in it, but if it has less prestige or if it has less money, that's a problem. You can't do that. But if you have a position that has slightly different duties, a little bit less pay, you can always increase the pay so that they are at an equivalent relatively equivalent position as before. If you get into a position where you're really struggling with that, then that's a good time to get your company counsel involved to help you figure that out and craft a solution. So that is FMLA in a nutshell. It's a pretty big nutshell. And I would be happy to answer any questions that you have before the class starts. Just reach out by email or text, and we can talk through it and make sure that everyone is up to speed and everyone understands at least a basic working knowledge of FMLA and ADA so that you can get the most possible out of our group exercise and continued discussion on these issues. Thank you.